Hello, my name is Ray Kerlick. I'm a partner with the law firm of Wadler, Perches, Hundl, and Kerlick in Wharton, Texas. Today I'd like to talk a little bit about covenants not to compete and non-disclosure agreements, or NDAs. Most people are familiar with these terms, and most people have probably even seen one because many folks have signed them. There is a lot of misconception among lay people, and frankly there's some confusion in the law about how enforceable these items are. I'll do my best to kind of summarize what I understand the current state of the law to be. Covenants not to compete can be enforceable and often will be enforceable. They do have to be reasonable both in scope and duration, and they do have to be supported by some type of consideration. However, this consideration can be the provision of confidential information such as pricing, customer lists, and other items that would be the natural course of business as being an employee. So no further consideration is necessary than that. So to the extent someone's told you, don't worry, in Texas, covenants not to compete are not enforceable, it certainly isn't true. They're not blanketly enforceable, but they certainly are enforceable within certain guidelines. So prior to signing an employment agreement that includes a covenant not to compete or a non-disclosure agreement, you should at least take this by the attorney of your choosing and let him or her review that with you briefly. I don't think that any potential employer is going to be taken aback by that. They certainly had a lawyer draft the version that they're handing you, so they shouldn't be in any way offended that you're going to have your attorney take a look at it and determine whether we think it's reasonable or overbearing in some way. Now, non-disclosure agreements are also enforceable, and a non-disclosure agreement is just what it sounds like. You agree that should you be the recipient of certain confidential information from your employer, that you won't disclose it to someone else after you leave their employment. I will tell you that these are certainly much more enforceable even than a covenant not to compete. Indeed, I think the assumption probably by most courts is that you did have access to any confidential information at the business, and that more likely than not you will disclose it unless specific precautions are taken to make sure that that doesn't happen. Now, in the setting where you have actually signed either a non-compete or a non-disclosure, there's a few items to keep in mind, and that is, should you choose to leave the employment, there's always the possibility that you can negotiate the release or removal of these restrictions from you. Certainly if you're leaving on some type of disputed terms, that's certainly something that you can discuss with your employer. Even if you're leaving on good terms, it's something that you ought to discuss with your employer. If that's not possible and you've moved on to another job, it's certainly something that you should bring to the attention of your future employer as quickly as possible, and quite frankly, normally before you're hired. Oftentimes, these companies who may be competitors are going to be familiar with the specific provisions included in these contracts, and they'll know whether or not they feel comfortable taking you on as a new employee based on what they have seen in the past dealing with this particular provision. In the normal analysis, further, they'd be the party who is also involved if there's a lawsuit that stems out of this. So they'll actually be named as a party. And so you don't want them, the first notice they have of the fact that you have a covenant not to compete, to be that they've been sued. So again, if you have signed one, it's frankly, I think, a smart idea to let any potential employer know that it's out there. Make sure they're familiar with the language, and again, most of the time they'll be familiar with what generally the restrictions are and what they can limit you to doing until such time as that covenant not to compete expires. Again, should you reach the potential place where you are thinking about or talking about a lawsuit, you should certainly immediately contact a lawyer, because recognize that there are emergency provisions available to the employer that could actually limit your ability to even go to work at a new employment, subject to a release of that covenant. So again, these are very serious issues and certainly not ones that should be taken lightly. Take the opportunity and take the time to consult with an attorney of your choosing. We'd be happy to discuss any of these issues with you at further length and appreciate your time. Thank you.